Hi, welcome to Chapter 5. We're going to talk about the Declaration of Independence and the Constitution. I want to start with two sentences, both written in 1776 by the same person, both claiming to express universal human truth. The first, we hold these truths to be self evident that all men are created equal, and that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. The second, the person's enslaved workforce at the time he wrote these words and um, numbered approximately 175 people. By his death in 1826, he had enslaved over 600 people. He freed only two of them in his lifetime. The author, of course, was Thomas Jefferson. And this contradiction between the Declaration's soaring universal claim and the actual conditions of American life in 1776 is not a footnote. It is the central productive tension of American constitutional history. Every civil rights movement in American history has deployed the Declaration's language against the exclusions of those who wrote it. Lincoln's Gettysburg Address reframed the Declaration of the nation's fundamental promise that subsequent every generation was obligated to fulfill. Frederick Douglass used it as a weapon against slavery in 1852. Martin Luther King called it "I Have a Dream" speech. But the founding documents are not dead history. They are living documents about Americans' promise about how far short it had fallen. And those arguments are playing in the Supreme Court constantly right now. So I want to talk about the learning objectives from today. The first five of these five is explain Hobbes and Locke's social contract theories. The second is analyze the Declaration of Independence through natural rights and sovereignty. The third is describe the Articles of Confederation and the Constitutional Convention. Fourth is identify the major constitutional compromises of the Great Compromise. And the fifth, explain the constitutional interpretations of originalism versus living constitutionalism. Both Hobbes and Locke begin from the same thought experiment. Imagine human life without government, without laws, without courts, without police or armies to enforce agreements. What would that be like? This is the state of nature. The exercise is not historical. Neither philosopher thought that humans had literally lived this way. It was a logical device for identifying what government is for and what it must be like to be legitimate. Their answers to the same thought experiment are radically different, and those different answers map differently into the tension between security and liberty that runs through the entire American constitutional tradition. Hobbes. Hobbes published the Leviathan in 1651 during the English Civil War, a context of political catastrophe and social dissolution that shaped his conclusions deeply. For Hobbes, the state of nature without government is a condition of perpetual war. Every person faces every other person as a potential threat. There is no industry, no agriculture, there's no culture, there's no knowledge because the returns on investment are too uncertain when anyone can take what you have. Life, in the immortal phrase, is solitary, poor, nasty, brutish, and short. Hobbes' solution: surrender all power to an absolute sovereign, the Leviathan, who enforces peace by being more powerful than any competing force. The contract between subjects and sovereign, you give up essentially all your national freedoms in exchange for physical security. And crucially, you cannot take it back. Once the sovereign is established, there is no right or revolution, because revolution returns you to an intolerable state of nature. Hobbes is the philosopher of authoritarianism, and his reasoning is not absurd. The appeal of order over freedom is genuine for people who have experienced the alternative. When Hobbes says liberty must be sacrificed for security, he is making an argument that still resonates from authoritarian leaders who promise order to citizens who experience violence and chaos. Locke, though, through the liberty is protected by the government, published in the two treaties of government in 1689 in the context of the Glorious Revolution, a very different political movement, one of the most successful constitutional settlements rather than chaos for Locke. For Locke, the state of nature is not war, is free and governed by natural law, moral rules discernible by reason that apply to all humans equally. The problem with the state of nature is not that it was violent, but it was insecure. There was no natural enforcement mechanism for natural rights, so conflicts have no reliable resolution. Locke's contract is fundamentally different from Hobbes. You do not surrender all power, you delegate specific powers to government for the purpose of protecting the natural rights that you already have: life, liberty, and property. Locke's triad that Jefferson would adopt to life, liberty, and the pursuit of happiness. The government exists to serve those rights, not to override them. And if government systematically violates the rights it was created to protect, it becomes tyrannical. The people retain those rights to abolish it or to alter it. And the right of revolution is not catastrophic, it's the logical consequence of the original purpose of the contract between people and government. Natural law, positive law is important. The distinction between natural law and positive law is crucial for understanding the American constitutional theory. Positive law is a law enacted by human authority, statutes, regulations, constitutions. It's valid because legitimate government authority that enacted it says so. It cannot be changed by the authority. Natural law is something different, universal moral rules that exist independently of human rights and enacted and are discoverable by reason. The founders grounded the Declaration's rights claims in natural law, endowed by the Creator. It said these rights come from God and nature, not from government. And the implication is profound. If rights come from government, government can take them away. If rights come from God and nature, if they are natural and inalienable, then there's no government, no majority, no legislator has ability to abrogate your rights or take it away. The government cannot take what it did not give, only God gave it to you. This is why the Bill of Rights takes the form it does. Congress shall make no law, the government is being prohibited, not authorized. Rights are not granted by the Constitution, they pre-exist it and are protected against the government's intrusion by it. So it brings us to our Declaration of Independence. Declaration of Independence is not a proclamation or a poem, it's a legal argument. Its structure is syllogistic, a major premise, universal principles, minor premise, evidence of tyranny, conclusion, independence is justified. Understanding it as an argument, not just as a document, is the key to understanding its enduring power. The preamble establishes the major premise that there are universal natural rights, all men are created equal, a claim that was radical in 1776 when most of the world was governed by a hereditary monarchy on the premise that birth determines station. These rights are unalienable. They cannot be legitimately taken by any government. Among them are life, liberty, and the pursuit of your happiness. And governments derive their powers from the consent of the governed. If a government system systematically destroys rather than protects these rights, the people may alter or abolish it. The middle section of our Declaration of Independence takes up the document's length, which almost no one reads. It's the evidence that 27 specific grievances we had against George III, each designed to demonstrate the British government has systematically violated the rights of the colonists. So, understanding this section is essential to the argument's logic. And the revolution is not unconditional. It requires evidence that the government has fundamentally failed in its purpose. That Jefferson's 27 grievances are that evidence we provide. And the conclusion formally declares independence and pledges our lives, our fortunes, and our sacred honor, the mutual commitment of the signers that transform an argument into a political act of real consequences. So there are contradictions and the legacy that comes. The contradiction is stark and must not be glossed over. Jefferson wrote that all men are created equal, enslaving 175 people at the time and 600 over his lifetime. Women, enslaved persons, Native Americans, populous men were explicitly excluded from the political rights the Declaration claimed to rest upon as universal principles. So the productive tension, these exclusions were visible and indefensible by the Declaration's own logic, and the document's universal language created a permanent indictment of American practice. Every person excluded from its promises could invoke these premises against exclusion. So by 1863 in Lincoln's Gettysburg Address, it's the canonical reinterpretation. Lincoln deliberately conflated the Declaration and the Constitution, describing the nation as conceived in liberty and dedicated the proposition of all men are created equal in the Civil War as a test of whether such a nation can survive. Every subsequent civil rights movement has followed the template, including invoking the Declaration's universal language, identifying specific exclusions and betrayals. We see things like the Seneca Falls in 1848 with women wanting equal rights, and Martin Luther King's I Have a Dream. We started with the Articles of Confederation within our history. It was a deliberate experiment to minimize national government. 13 states had just fought a revolution against centralized imperial authority and were not eager to create a new one. The Articles of Confederation were a way to give the Congress the power to request but not to demand taxes from the states. No federal courts, no power to regulate commerce. The results were entirely predictable. States refused to pay their requisitions. Congress was perpetually broke and could not survive from the war debts it had, and states began imposing tariffs on each other's goods. Then came Shays' Rebellion, which was the political trigger for constitutional reform. And Shays' Rebellion in Western Massachusetts in 1786 and 1787 Massachusetts farmers were unable to pay their debts due to the economic depression following the Revolution, organized a series of armed protests that disrupted court proceedings and threatened the Springfield Federal Arsenal. The state's militia struggled to suppress the rebellion, and Congress cannot provide federal troops because it had no authority to tax and therefore no money to pay soldiers. The rebellion terrified the founding generation, including George Washington, who wrote an alarm that the country was descending into anarchy. It demonstrated that Articles government was too weak and they had to do something different. They called a constitutional convention. 45 delegates gathered in Philadelphia in May 1787, ostensibly to revise the Articles of Confederation, but quickly decided to write an entirely new constitution. The average age of the delegate was 42. James Madison, at 36, had prepared extensively, developed what became the Virginia Plan, the blueprint for a strong national government with proportional representation, both in legislators' chambers. The final product required three major compromises, which the Constitution could have before the Constitution could be ratified. The Great Compromise between the large and small states produced what was called bicameralism, and it's a state with equal representation satisfied the small states, and the House of proportional representation satisfied large states. And the third was the Three-Fifths Compromise, was an explicitly immoral bargain. It said that enslaved persons had no legal rights to vote and were counted as 3/5 of a person for the purpose of apportioning House seats and the Electoral College votes. So giving enslaved states substantially more political power without giving enslaved people any legal status. This Electoral College was a compromise between those who wanted direct popular election and those who wanted Congress to choose the president. It gave slave states additional weight through the 3/5 counting process. The ratification and the Bill of Rights of the Constitution. The Constitution was sent to the states for ratification, where it faces determined opposition from anti-federalists, Patrick Henry, George Mason, Richard Henry Lee, who argued it would create a dangerous national government and swallow the states and eliminate individual liberties. The Federalists like Hamilton, Madison, and John Jay, writing the Publius and the Federalist Papers, mounted a sophisticated defense. And the promise to add a Bill of Rights immediately upon ratification secured the crucial votes in New York, Virginia, Massachusetts. First 10 amendments were ratified in 1791. The Constitution design came, and the separation of powers and checks and balances were put into the place of the Constitution. The Constitution describes the federal powers among these branches, each with distinct functions and each with tools to check the others. The architecture is explicitly derived from Montesquieu's theory of the balanced Constitution, adapted for a republic. Article 1 vests the legislative power in Congress, the power to make law, control the purse, declare war, regulate commerce, coin money, provide for the general welfare. The House has the sole power of impeachment. The Senate has the sole power to try the impeachments like a trial, ratify treaties, and confirm presidential appointments. Article 2 vests the executive power in the president, the power to faithfully execute the laws, serve as the commander-in-chief, negotiate treaties, appoint officers, grant pardons, and the president can veto legislation. Article 3 vests judicial power in one Supreme Court and in such inferior courts as Congress may establish. Judges hold their offices during good behavior for tenure, and their compensation cannot be reduced. And then that has the power to strike down laws that are unconstitutional was given by the case Marbury versus Madison in 1803 because it wasn't explicitly stated in Article 3. The checks are mutual and overlapping. Congress can make laws, but the president can veto. The president nominates, the Senate confirms, Congress can impeach, the courts can strike down. So we have certain laws that are called enumerated laws, implied laws, and reserved powers. Article 1, Section 8 lists the enumerated powers of Congress, things that Congress is explicitly authorized to do: tax, borrow money, regulate commerce with foreign nations, among states, coin money, establish post office and roads, raise and support armies, declare war, and crucially, the necessary and proper clause. It's where Congress has the power to make all laws which are necessary and proper for carrying the execution the foregoing powers that's needed. This is the elastic clause, the constitutional hinge, which almost all modern federal power rests. The McCulloch versus Maryland established the broad reading: necessary does not mean absolutely indispensable, it means reasonably appropriate. If the end is legitimate and within the scope of the Constitution, all reasonably appropriate means are considered available. Implied powers are the powers normally necessary and proper for carrying out all enumerated powers and are on the basis of virtually all modern federal regulatory activities. So federal drug laws, environmental laws, workplace safety regulations, consumer protection, all rest on this commerce clause and the necessary proper clause. The last one we want to talk about is called the reserved powers, the 10th Amendment, which specify that powers not delegated to the federal government are reserved for states' rights and the people. The provision has been the textual home of states' rights arguments throughout American history, and its actual operation effect depends entirely on how broadly enumerated implied powers are read. The constitutional interpretation in 2026 is important. How should judges interpret the Constitution? It's not an academic question. It determines who wins major constitutional cases, and therefore who has rights, who has power, and what government can and cannot do. There are two major competing methodologies that produce systematically different results on major constitutional questions, and these are important. Originalism asks, what did the constitutional text mean to those who ratify it? The meaning of the Constitution is fixed at ratification, meaning the Constitution meant what it meant when they wrote it. Applying it to new circumstances requires asking what the original meaning implies about those circumstances. Justice Scalia was the most prominent articulator of this methodology. Judges are not authorized to update or adapt constitutional meanings. Their job is to apply the meaning that the democratic process established when the provision was adopted. The appeal, originalism, constrains judicial discretion, keeps courts from becoming unelected policymakers, and respects democratic self-governments. Then the other theory of the courts is that there's living constitutionalism. What do the Constitution's broad principles mean in application conditions that the framers could not have anticipated? So there are things that will happen now that the framers could not have enumerated, and that people believe that the law is living and breathing, and the Constitution is living, breathing document. Framers wrote open text provisions, due process of law, equal protection laws, cruel and unusual punishment that invite, even require, evolving interpretation. Justice Brennan was a canonical living constitutionalist, and constitutional principles that must be applied to the conditions of contemporary life, and that the court's role is to ensure the constitutional promises are redeemed as society's understanding of human dignity and equality develops, according to Justice Brennan. Recently, the 6-3 conservative and supermajority created by Gorsh in 2017, Kavanaugh in 2018, and Barrett in 2020 has developed originalist methodology to produce the most consequential transformations of the court since the Warren Court. So Dobbs versus Jackson in 2022, Dobbs overruled Roe v. Wade and Planned Parenthood versus Casey, holding the Constitution does not protect the right to an abortion. Justice Alito's majority opinion is a textbook originalism. Abortion is not mentioned in the Constitution, it's not deeply rooted in the nation's history, and Roe was wrongly decided from the start, it was said. Returning the question to state legislators was the federalism view and then also the constitutional view. Justice Sotomayor's dissent is the living constitutionalist response. Roe was part of a broader constitutional framework protecting personal autonomy and equality, overruling it 50 years after it was decided when millions of women have organized their lives around its protection is not principled textualism, but selective originalism used to reach a predetermined conservative result. So these major ways that we live in society and we change our how we interpret the law really impact on how we point people to the courts and how we live in our modern times. I thank you for tuning into our lecture today.